Welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us today. As you know, the Data Practices Office is a small office in the Department of Administration, and we are a statewide resource on data practices and the open meeting law. And most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about either of those laws or both, please feel free to reach out to us at any time. We also help the Commissioner of Administration with her responsibilities, one of which is issuing non-binding advisory opinions, and we also provide legislative assistance and training. For those of you who are watching this in real time, it's at the end of February 2022, so the legislature is in session and the Data Practices Office is tracking some of the data practices and open meeting law legislation that's making its way through the process. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered. We also record our webinars, so if you missed part of today's webinar or want to go back and watch it again, or find one of our prior series, they are posted on the Data Practices Office YouTube page, and you can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after the webinar. If you'd like to download a copy of the PowerPoint right now, I am going to share a file with you. Once you see it come up, you can select the file and download it to your device or computer. You should see that popping up right now. Again, you select it and then you can download it if you would like a copy. Today's webinar is another installment of the Data Practices Potpourri, where we highlight some of the questions data requesters and government entities raised in the last couple of months. We will leave time for a question and answer session at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen, and make sure you choose all panelists when you send your questions so we can be sure to see them. You can start sending them right now, or you can wait till the end of the presentation to send them as you think about them. Okay, the first question today is about copy costs. And the question is, can a government entity charge tax on copy fees? There are a lot of complex data practices questions with it depends kinds of answers, but here we have a straightforward, clear answer. The answer is no. Government cannot charge tax on copies. Minnesota Rule 8130.9300, subpart 2 says, if law or ordinance requires a governmental agency to furnish copies of documents held in its files, the furnishing of such copies is a governmental act or service and shall not constitute a taxable retail sale. So Chapter 13 requires entities to provide copies upon request. So read with this rule, entities cannot charge tax on copy costs. And you can also take a look at Advisory Opinion 95-053, which is an older one, but still helpful on this question. The next question is about remedies, and someone asked us, is there a sanction for not updating access policies? Section 13025 requires government entities to have access policies for members of the public and for data subjects. That provision also requires entities to review their data access policies by August 1st of each year and update them when there's a personnel change. And the remedies for violations of the Data Practices Act are found in sections 13.08 and 13.085. So 13.08 provides relief to any aggrieved person seeking to enforce the person's rights under Chapter 13 or the right to obtain access to data. So if an entity does not have updated policies, it's possible that a data requester could file an action to compel compliance in district court or recover for any damages they sustained. I'm not aware of any case where this has happened, but just noting that Section 13.08 remedies could be available and maybe as a part of a larger action with a number of data practices issues. Section 13.085 allows a complainant to file a complaint at the Office of Administrative Hearings requesting an order to compel compliance. So if policies are not updated and accurate, a data requester might go to OAH and use that process. For entities, just as a good practice, noting on the policy when it was reviewed last or updated just lets folks know that it is current. Especially nowadays when employees are moving around quite a bit, your responsible authority or your DPCO or designees might change. So making sure your policies are up to date is critical. And from our perspective at the Data Practices Office, we definitely look for and use access policies in the work that we do with requesters. And we really appreciate knowing that we're connecting with the correct person when we have a question about data practices. We do have model policies on our website, along with a worksheet of decision points for entities looking to revise or review their policies. The next question is another sort of back to basics question, but it is a topic that we received a few questions about recently, which is when does a government need to obtain informed consent and what are the requirements? So an entity is required to obtain informed consent when the entity maintains private data on individuals and the entity wants to share it with another party or use the data in a way that was not included on the tenancy warning notice. So we encourage entities to list as clearly as possible those who have the statutory right to access private data upon collection when providing the tenancy warning notice. But if something changes or an entity or party is left off the tenancy warning, then the government entity may need to obtain informed consent. An example of this might be an ID badge photo for a public employee that's private, and the data subject was provided a tenancy warning notice that their picture was being taken for security purposes. But let's say now they want to use it for a newsletter. In that situation, that's a different kind of use. They didn't have authority for when they collected it, and so the entity would need to obtain informed consent from the data subject in that situation. Another situation where informed consent is required is when the entity wants to share data it created or collected from someone else. So it's situations where a tenancy warning was not required because the entity is creating the private data or the private data was collected about somebody else or from somebody else. And that's a situation where maybe there was a program that was created and you want to share private data to coordinate services, but there isn't statutory authority to do that. In that circumstance, an entity would need to get informed consent from the data subject. And then finally, a third circumstance is when the data subject wants to share their data, their private data with someone else. And so this might be a student asking to share their GPA or their class rank with the college they're applying to, or an employee who's interviewing for another position and they want their supervisor to share private personnel data in a reference. In those circumstances, the government entity would need to get informed consent. Informed consent, the requirements for informed consent are that it is voluntary and not coerce. It's in writing, explains why the new use or release is necessary. It includes any known consequences for giving informed consent. And if the individual is a minor or has a legally appointed guardian, the entity may also need the signature of the individual's parent or guardian, depending on the situation or the entity's policy. So the Data Practices Act does not have requirements for how old someone needs to be to provide informed consent. So unless there's a law outside of Chapter 13 that provides that requirement, entities can make their own judgment as to whether a minor is sufficiently mature to provide consent to share their data. An entity might consider the policies that they already have for assessing whether a minor is mature enough to request that their data not be shared with their parents or guardians, and then use a similar standard for informed consent. And then also consider that entities must protect private data, so the entities will want to consider how to verify that the person signing the informed consent is indeed the data subject. And you can look to your access policies on how you verify identities for data subjects, for data subject requests for private data. And ultimately, that's going to be a risk assessment for each entity. Shifting gears a bit, we had several questions about drones this month. Section 626.19 is a newer section that applies to law enforcement agencies that create or maintain drone data or unmanned aerial vehicle data, as it's referred to in the statute. So if your entity has a drone but is not part of law enforcement, then this section does not apply. So either the public presumption applies or the statute's related to your work. So that's an it depends. But if you are a law enforcement agency and you have a drone, 626.19 is where you would look. Drone data includes all the types of data that a drone might collect, and apparently there's a lot of different kinds of data that a drone could collect, including not only video, but apparently it can detect changes in wind, weather, infrared data. Some can note chemical signals. So all of the data that the drone collects for law enforcement is subject to this provision. And the treatment of drone data is similar, though not exactly the same, as data collected by body cameras. So generally, drone data is going to be private or non-public, but can be disclosed in certain circumstances. If the data become part of a criminal investigation, then they're classified as law enforcement data under 1382. Once the data become inactive investigative data, then they become public. There are a number of administrative provisions in 626.19, so you're going to want to take a look at those if you are thinking about getting a drone or what's required in order to have a drone and maintain drone data. We also have some information on our website about it. We've had a few questions both from the public and government entities around accessibility recently. And so just this broad question, what are the accessibility requirements for the Open Meeting Law and the Data Practices Act? The short answer is that neither the Data Practices Act nor the Open Meeting Law contain specific references to accessibility. The much more complex answer, which requires a much longer webinar, is that the government is subject to both the Americans with Disabilities Act, and specifically referring to Title II here, and Section 363A.42 in Minnesota law, which says, among other things, reasonable modifications must be made in any policies, practices, and procedures that might otherwise deny equal access to records to individuals with disabilities. So while the Data Practices Office is not, we are not experts in this area, we know that accessibility issues can impact implementing the requirements of chapters 13 and 13D, and that these other laws require reasonable accommodations so that people with disabilities can fully participate in and access government services and programs. Reasonable accommodations will need to be made on a case-by-case basis based on the request of the individual and the entity's ability to provide accommodation. So for government entities, if you get a request for an accommodation, you'll want to connect with the ADA coordinator at your entity to help facilitate access to data or to a public meeting and determine what constitutes a reasonable accommodation. For requesters and attendees, meeting attendees, you want to reach out to the responsible authority or DPCO or the public staff that facilitates meetings to request a reasonable accommodation as soon as you know you need one. And finally, we had some questions on criminal history data. And generally, it was how are criminal history data classified? This question is based partly on the drafting of section 13.87, which can be a little confusing. So criminal history data are classified by section 13.87. They're defined as criminal history records compiled by the BCA, including fingerprints, photographs, identification data, arrest data, prosecution data, criminal court data, custody, and supervision data, amongst other things. Criminal history data that other government entities obtain from the BCA are private data on the individual. The public classification in subdivision 2B only applies to the BCA. So criminal history data are private at other entities. So one note is that an entity may have collected similar data. For example, law enforcement collects arrest data as well, which are public under 13.82. But section 13.87 only classifies the criminal history records an entity has received from the BCA. You can also check out Advisory Opinion 94-031, which is another oldie but goodie. So those are our questions for today. Let's take a look at some of yours. Remember to send them to all panelists so we can make sure to see them. A few reminders on the slide that the slide deck is available at our website, and you can access the recording on our YouTube page in the next day or two. I'm also going to put up the evaluation in the polling panel. If you would please fill that out and let us know how we did and what other topics you'd like to see in the future, we would really appreciate that. And we will be taking a look at some of your questions and responding. If we don't get to your question during the webinar, we will follow up with you afterwards. So I'm opening the poll, and also please keep sending in your questions.
Okay, so our first question today is, if a requester wants to inspect data, can we still send the data via email instead? It looks like instead of providing in-person inspection. In parentheses, they say due to limiting persons in the building. So if in lieu of having somebody come in person to inspect data or inspecting in some other way, you can provide free copies. So free copies are an option. Here, the person specifically asks via email. If it's electronic data and you would like to send a free copy of the electronic data to the requester for them to inspect at their own location, that would be sufficient to satisfy inspection requirements.
So we had a question that says about informed consent. It says, the in-writing requirement, has DPO ever evaluated whether click wrap consents meet the requirement? So I'm not sure exactly what click wrap is. However, I will say that in general, electronic signatures are still considered signatures, so that, you can use technology to obtain consent.
Okay, so we had a question, can you touch on retention requirements for data practice responses? The retention requirements will probably change by entity, so we would suggest consulting your entity's retention schedules to see how long you should maintain those responses. And if we're silent here, we're reading over other questions that come in, so just bear with us a minute. Thanks.
Another question that came in is, should an entity maintain vaccination status information since the ETS is no longer in place? Whether an entity is deciding to collect certain information and whether they have to continue to maintain it is more of a business decision for that specific entity and what their retention schedule requires them to maintain. If it's an official record and they already have it and they have to continue to maintain it pursuant to the retention schedule, that will be different depending on each entity and what their official records are.
We had a question about the data practices data breach section, which is in 13.055, which is there a definition of non-governmental purpose in that section, and there is not a definition of that. So it would just be a plain language definition in that the data is being used not for either the intended governmental purpose or a governmental purpose, or accessed without a work assignment requiring allowing access.
I have another question. It says, is there any effort or consideration of undertaking an effort at our office to place boundaries on parties' ability to weaponize the DPA through repeated nonsensical or otherwise unreasonable data requests? There is not an overly burdensome requirement in the Data Practices Act. Our office generally takes a neutral stance on the law as we help both government and members of the public in trying to understand data practices and data practice obligations. And so we don't generally advocate for one position or another. If an interest group is interested in going to the legislature and making a change, we're happy to discuss what changes they would like to make and talk about the language they're proposing with them to see if it would actually make the change that they're trying to enact. But we don't go to the legislature to try to make substantive changes to whether or not somebody's able to make a data request.
We have a question about sort of the intersection between data practices and the open meeting law. And it says, we conduct a background investigation for certain city business license and the city council needs to approve it in a public meeting. Can we disclose in the report to the council during a public meeting that nothing has been found in the background investigation that would prevent a license being issued? What can we say in the report if certain criminal history information was discovered that could potentially prevent a business license being issued? So for the meeting piece, section 13D.05 allows public bodies to talk about not public data in a public meeting, in an open meeting, if they need to do so to conduct business. And so certainly the discussion can be had. That provision also provides that the underlying data maintain its classification, so that wouldn't be something that would be put in the public packet and available to the public, though a record of the meeting would be public. So if, for instance, the meeting was recorded and then put on YouTube or something like that by the city, then that would still be available to folks. What can we say in the report if certain criminal history information was discovered? So again, the underlying data you would continue to protect, and any sort of criminal history data that came directly from the BCA would need to be protected as private under 13.87. But again, the conversation about it could be included in the public meeting.
I have another question. With all of the identity theft going on now, can we redact the date of birth and phone numbers when releasing inactive investigative data? I'm assuming this is law enforcement data. With 1382, there is not a general date of birth or phone number classification. There's not a general date of birth or phone number classification in the entire Data Practices Act. There is section 13.37, which is the security information section, and it says that if the release of the data would be likely to substantially jeopardize the security of information, possessions, individuals, or property against theft, tampering, improper use, trespass, some sort of injury, then it can be classified as security data, which would make it private. But these security information determinations need to be made on a case-by-case basis. So the release would need to be likely to substantially jeopardize the security of information in that instance. It's not a broad decision that the entity would be able to make. You can't say we're always going to redact date of birth and phone numbers. That would not meet the requirement of 1337. So it must be made on a case-by-case analysis. Again, this might be something that you would want to take up with the legislature in the future if that's something that you think is a concern, or if identity theft means that we should be protecting other types of sensitive information about individuals. But right now, there is not a general classification for date of birth or phone numbers.
Okay, we have a few minutes left, so feel free to send in your questions. If you can't think of any now, please feel free to call us or email us with them in the future. Just a reminder that the poll is open. Please fill it out if you have a chance. It helps us to tailor these webinars and our trainings to your needs. Thanks. We have a very specific question about why section 13.468 was repealed. And that section related to intra-county sharing, and there was kind of some limitations around what could be shared within the county, because generally private or other not public data can be shared within an entity with those who have a work assignment need. And so obviously a county has many departments, this does many things. And 13.468 was a limitation on some of that sharing. I believe at the same time that was repealed, additional language was added to section 13.46, which is called the welfare data section that allowed or made clearer some of the required sharings within what's called the welfare system, or defined in that section as the welfare system. So I think that's why it was repealed, that it was clarified in 13.46, and then the rest of the sharing within the counties just is the general rule that not public data can be shared within one entity as needed for work to get done.
Another question, it says, it's odd when the member of a governing board makes data requests to the entity he or she governs, but I see no restriction on his or her doing so above and beyond what applies to anybody. Do you? Nope. If the person just wants to make a data request as a member of the public or as a data subject, they are able to do so just like anybody else would be able to make a data request.
All right, last call for questions. We have a little bit of time left. Okay, Well, thank you for joining us today. That's our time. Thanks for your attention and sending in your questions. Stay tuned for a Gov Delivery notice about our next webinar. For those of you who are new to data practices, we are having an Intro to Data Practices workshop on March 15th, and the registration is open and available. Thank you for joining us and have a great day.